Justice Barrett?
General, I want to ask a clarifying question about the distinction in the government's charging decisions between C1 and C2. Actually, let me make that stronger, not charging decisions, like what you could charge under the statute. So as you pointed out to Justice Kavanaugh just now, C1 has this additional mens rea requirement, but, there is overlap if you read otherwise obstructs, influences, etc. Broadly, it would encompass, frankly, even on the other reading, it would encompass things like alters, destroys, mutilates, etc. But you wouldn't have to prove the extra mens rea. I thought I heard you say, and I just want to clarify to Justice Jackson earlier in the argument, that the government could not charge an alteration, mutilation, concealing a document or physical object under C2. Am I?
That's correct. We usually charge the specific paragraph, and so if the conduct fits within C1, we would charge it under C1, and that would be the proper place to locate the charge.
And is that charging, is that prosecutorial discretion, or do you think the statute would permit you to charge it under C2, thereby escaping the specific intent requirement?
Well, let me say that there is a specific intent requirement under C2, so there's no distinction between them in that regard. Right, it's the intent to obstruct the official proceeding. So you're right that we wouldn't have to prove intent to, mutilate a document or something, but we would still have to show the intent to obstruct the proceeding. This is pressing on, honestly, what's a difficult question about means versus elements, and I think the best reading of the statute is that these are different elements because they have these different actus rei, they have the different mens rea requirement, the mens rea requirement that's specific to C1. They each independently prohibit attempts, but it's a hard question ultimately. And if we charged under the wrong paragraph accidentally, I think we could usually say that that was harmless error or else recharge under the correct paragraph.
Okay, let me ask you a question that kind of gets at some of the same points that Justice Alito's questions were getting at. So what if on January 6th, the Capitol itself had not been breached, the protest is going on outside the Capitol, stop the steal, police are, in megaphones saying disperse, disperse, they're too close to the Capitol, their goal is to impair, impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
So I think that one relevant question would be whether we could satisfy the nexus requirement and show that actually the natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and
yes,
in the
so
mind run.
You can.
Yes. So if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we had, for example, organizers where it was absolutely clear that they were the ringleaders who had intended to obstruct and undertook the action with that specific intent and did so knowing it was wrongful, and especially if they went, I'm assuming you're saying they're in the unauthorized area right outside the Capitol, that is unlawful conduct committed with consciousness of wrongdoing if we have the proof of it.
Let's say that I am having a hard time accepting your limiting construction of the verbs obstruct, influence, or impedes to have this extra element. Tell me why I shouldn't be concerned about the breadth of the government's reading, just relying on corruptly and the nexus requirement. Should I be concerned, or could you just embrace it and say, yeah, there might be some as-applied First Amendment challenges or that sort of thing? I mean, can I be comfortable with the breadth if that's what I think?
Yes, you can be. You certainly don't have to agree with us that a de minimis hindrance wouldn't qualify. If you thought that this was unqualified and swept broadly to any kind of hindrance whatsoever, there would still be really important limits in the statute. Obviously, you'd have to have the official proceeding. I think the nexus requirement could be somewhat harder to establish in a circumstance where you might not think that the natural and probable effect of the conduct is going to be to obstruct the proceeding. You'd have to show that the defendant knew that the natural and probable effect would do that. You'd still have to show the corruptly mens rea. And as you mentioned, even if you could show all of that, if it were a circumstance that really did infringe on First Amendment rights, there would always be the backstop of an as-applied constitutional challenge.
Do you think it's plausible that Congress would have written a statute that broadly? I mean, let's say that I think that Justice Alito's example of the protesters in the courtroom, let's say it's corrupt. It impedes the proceeding because we have to go off the bench and things are stopped. Let's say I think that that's covered by the word impedes, and there's the nexus and it's corruptly. Is it plausible to think Congress wrote a statute that would sweep that in?
Yes, I think that there are a lot of legitimate ways to try to voice your dissent if you disagree with what the court is doing, but one of the ways you cannot do it is come into this courtroom, halt the proceedings, force the justices to leave the bench, and do it with the intent and the corrupt mens rea. I think that Congress could think that is a severe intrusion on the functioning of our government and want to protect against that. And again, the 20-year statutory max, of course, is just a max. There's no mandatory minimum. So Congress would have recognized that sentencing courts would use their discretion to tailor the actual sentence to the facts of that specific offense.
Thank you.